Good morning, counsel.
Good morning, Your Honors. May it please the Court. Leslie O'Brien for William Santos. In relation to the first issue in Mr. Santos's brief, he says that his Fifth Amendment rights were violated when police continued to question him after he had asserted his right to counsel and his right to silence. There are two principal points in this argument, and they are, first, that Mr. Santos's assertion of his Miranda rights was clear and unambiguous. The second point is that Santos was plainly in custody, as custody is contemplated in Miranda. Taking the first question, addressing that first question regarding the supposed ambiguity, what Mr. Santos said while being questioned by the Lowell police was he was being questioned repeatedly regarding a particular white car. And he finally responded, "You ask Lou that. I'm not going on with this conversation. I want a lawyer because you keep. Ask Lou that."
And then he went on after that also.
He went on only to the extent of saying, "Don't ask me if he borrows." And then there was another question by the police officer, and he said Mr. Santos made another similar type of statement.
Now there's the ... after the word keep.
Yes.
And there was some reference to a redaction. Were there words that were redacted, or was it simply words that were inaudible?
My understanding was that was just that represents a pause. Now I could be.
I thought that what was redacted in terms of what went to the jury was the "I want a lawyer" part. Wasn't that redacted?
That was redacted, but of course it was heard and considered by the judge on
by the motion judge. I understand
the motion
that,
judge.
But is that the reference to the I don't know, but.
No. Now, I understood that, and it's been a while since I listened to the tape, but I understood that as simply a pause where the defendant said, "I want a lawyer because you keep," and there's a pause, and he says, "Ask Lou that." And the import of it, in context, it appears that what the defendant is saying is, "I want a lawyer because I don't like this line of questioning." And what I'm saying is that's whatever his reasons were for asking for a lawyer, you can't get much clearer than saying, "I want a lawyer."
But if you take what you just said, "I want a lawyer because I don't like this line of questioning."
Yes.
Is it not at least a possibility that the scope of what he wanted, that the scope of the saying "I want a lawyer" was a little ambiguous, and then the police came back and asked about that, and he said, "Yeah, I'll talk about anything. I don't want to do that."
But it's not ambiguous, respectfully, Your Honor, to explain why one wants a lawyer. If the defendant had said, if any defendant says, "I want a lawyer, I don't like the way this questioning is going," that should be enough. I want a lawyer. He's not saying, and I'd point out that he never says, "I want a lawyer if you keep questioning me about this white car." That's not what he says. He says, this conversation, I'm not continuing with this conversation. I want a lawyer because you keep. So he is objecting to the particular line of questioning. But I'd suggest that is ample. That's enough. If Miranda is to remain a bright line rule, then it can't be just wiggled around by the police saying, "Well, he gave an explanation, so maybe we can work around this explanation a little bit and keep questioning him."
What do we do with the fact that there was an ADA, I guess, outside the interview room, listening in, heard
Yes.
that, knocked on the door, said, "Okay, what's the story here? Do you want to," I forget the precise words, but seeking essentially to clarify whether he sought counsel or whether he did not want simply to discuss the car. And I gather the judge found that well, I'm not sure what the judge found actually as to that issue, because the judge found there was no custody. So, but I think one of the fair inference is that he said, "No, it's not. I'm prepared to speak. I just don't want to talk about the car." So is that a clarification of an ambiguous reference that should be sufficient for us or not?
But that's what he says on further questioning, and there's not supposed to be any further questioning because Edwards v. Arizona says there isn't to be any further questioning after he has invoked. And I'd point out, if I may, in Edwards v. Arizona, when the defendant invoked, when Edwards invoked, what he said was, I want a lawyer before I make a deal. So he gave an explanation for his wish for a lawyer. And the court didn't say, well, these officers who questioned him later on, they didn't say anything about making a deal. They weren't questioning him about the deal. So they could just go ahead and question him. Edwards himself gave an explanation for why he wanted a lawyer. And that did not give the officers leave to go back and say, well, if we don't talk to you about the deal, do you just not want to talk about the deal? His invocation was sufficient to cut off questioning. And I'd suggest that to preserve the bright line nature of Miranda and Edwards, that has to be the way it is. The police can't be allowed to just circumvent a request for counsel by saying, well, maybe we want to clarify he just doesn't like these particular questions. And I'd point out that the judge in her findings, although the judge obviously denied the motion to suppress, in her findings she mentions twice that the defendant requested counsel. She did not find any ambiguity in the request for counsel.
She didn't reach the question, did she? I mean,
she did reach the question.
I mean, she said, well, he did. I mean, there's no question that he said, I want a lawyer. And the question is whether, this is the question she didn't reach, I think, is she didn't consider whether that was a sufficient invocation under Edwards to cease all questioning or whether it was ambiguous because she found there was no custody. Is it?
She didn't appear to find any ambiguity, and I'd suggest that that's significant. She says the defendant requested an attorney when the detective was questioning him about the use of the white car. The judge was apparently not troubled by what's being raised now or being claimed to be an ambiguity. And I'm suggesting, I don't want to repeat myself, but it's different to be ambiguous. It's a different question whether one is ambiguous and one offered an explanation. He wasn't ambiguous. You can't get much more clear than, I want a lawyer. And adding an explanation, he certainly didn't have to add an explanation, but adding an explanation did not make, I want a lawyer, ambiguous. It would also be, of course, a very different case if he had said, if you keep questioning me along these lines, I want a lawyer. That's not what he said. It was a clear invocation, and the questioning should have stopped.
And that was litigated in the motion to suppress, the question of the ambiguity? The question as to whether there was an ambiguity.
It was raised in the Commonwealth certainly raised it. The Commonwealth claimed that there was an ambiguity. The judge did not indicate in any way in her findings that she saw ambiguity in the invocation.
Now, what do we do with the last line of page 5 of her decision, which says, I accept that the defendant is, again, this is referring to what you consider, what you contend is the attempt to undo the clear invocation of counsel, and what I'm sure the Mr. Bender will contend is the clarification of an ambiguous statement. But the court writes, I accept that the defendant is repeating again that he wants to, is willing to talk to the police, but just does not want to talk to them about who borrowed or who was using the vehicle.
But this occurred when the police continued to question Edwards, continued to question Santos after he had already asserted his rights. They continued to question him. They came back and said, well, would you like to talk to us about things if we stop talking about the car? And I'm contending that under Edwards, this is a bright line rule, they can't do that. They can't go back after he's asserted his right to counsel. They can't go back and say, well, how about if we only talk to you on this particular subject? Or how about if we avoid the subject that made you uncomfortable when you seem to be uncomfortable?
Now, the tape, I gather, was running during the discussion with the ADA and the police. That was after, so we can hear that. We can hear what was said to him immediately
Yes.
after the knock on the door.
Yes,
Because
that
there's no
was-
reference to it in the findings that she made as to what precisely was said to.
No, but it is in the tape, and it's in the appendix to the Commonwealth's brief. So you can see what was said. You can see that the police go back and continuing questioning him, and that's what the judge is referring to in her findings. In regard to the second part of the argument, Mr. Santos says that he was clearly in custody for the purposes of Miranda at the time of the questioning. And this was actually, of course, the way the judge disposed of the suppression issue. She said the defendant was not in custody for purposes of Miranda because he had been arrested, not on the murder charge, but on outstanding warrants. And what I'm suggesting to the court is that first, I have noted in my brief the lack of clarity about whether Larkin so completely contradicts the Supreme Court's decision in Mathis v. United States that it should be reconsidered for that reason. But even if it's not, this is a case that's distinguishable from Larkin because this is classic custody for Miranda purposes. The defendant was arrested by the Lowell police. He's brought to the Lowell police station. He's interrogated by the Lowell police and state police. He's clearly in their custody and in their control.
Well, I mean, one difference with Larkin is that Larkin was arrested on March 15th on the probation warrant, and the questioning at issue did not occur until July 21st. It was 4 months after the arrest on the probation warrant. Here it was the same day.
So there certainly are distinctions that can be made there, and there's also, I think, an argument that can be made where someone is in custody serving a sentence. If, for example, the Lowell police went to MCI Shirley to interview somebody, the person is clearly in the custody of MCI Shirley, but at least an intelligent argument could be made that they're not necessarily in the custody of the Lowell police at this point.
Do we know in Larkin whether or not he had been convicted on the probation violation? Because it was 4 months after. It was not clear from my reading of the decision whether that was pending the probation hearing or whether he already he'd been adjudicated on the probation violation.
I don't know. I remember that he was at the House of Correction, but whether he had been actually convicted, I can't recall from reading the case. As far as the argument that the police could question Santos on matters other than what he had been actually arrested for, I'd suggest that that's just a complete misreading of the case law. In reviewing Arizona v. Roberson. Arizona v. Roberson is one of the cases where the SJC cites the virtues of the bright line rule that's created by Miranda and by Arizona. And in that case, Roberson had been arrested on a murder and robbery. He invoked, and a day or two later, police came and interrogated him on a separate robbery, a separate crime. And it didn't really even seem to occur to anybody to argue that, well, he's not in custody, so he could be interrogated about this separate crime. I'd suggest that it's a clear-cut situation here. The judge in this case, what the judge did was to apply the analysis that applies when there's not a formal arrest. Here there was a formal arrest. When there's not a formal arrest, there's a four-part test involved where the court considers such things as the place of the interrogation, whether suspicion was conveyed, the nature of the interrogation. All of those things help the court to decide whether something is the equivalent of formal arrest. Here we have the formal arrest. There was formal arrest. Again, Mr. Santos was in the custody of the Lowell police being interrogated by the Lowell police. I'd suggest that a clearer situation of custody as contemplated by Miranda just does not exist. So those are the two main points that I hope to make regarding that argument, unless there are questions by the court on that.
If I could ask, with regard to the other points you made, with regard to Olga Gonzalez, with regard to her testimony in grand jury, was there ever an instruction by the judge that that should be used substantively under Day, or is that simply being admitted for impeachment purposes?
Well, the judge didn't instruct one way or the other.
Excuse me, wasn't there an instruction on the use of co-venture statements?
There was an instruction on the use
Didn't that indicate that they could use it if they, whatever the instruction said?
There was an instruction on the use of co-venture statements, yes.
But also, sorry, I thought there was one during the trial.
There was one during the trial also. I believe the question was a little bit different by Justice Gant.
Well, I guess there are two Olga Gonzalez statements at issue. I'm referring to the necklace and the gun, her observation with regard to the necklace and the gun, which would not, I think, be a co-venture statement. But
so I understood the question to be whether there was an instruction that the statement that the grand jury statement could not be used substantively, and there was not. There was no explanation. I know sometimes the jurors are instructed that prior inconsistent statement is not substantive evidence.
Was there any request by defense counsel for an instruction?
I don't believe there was, Your Honor.
Thank you, Counsel.
Thank you, Your Honors. Oh, I'm sorry.
Just a quick question on the, there was a motion to sever and you didn't raise that, but did these statements come up in the motion to sever, the Olga Gonzalez statements as a basis for, as a
I'm afraid
argument?
I don't recall, Your Honor. I recall that there was a motion to sever. I don't recall if that was the ground.
Okay.
Thank you.
Good morning. May it please the Court. My name is Robert Bender, Assistant District Attorney for Middlesex. With me today is Elizabeth Dunnigan, who tried this case and was the Assistant District Attorney outside during the interrogation of Mr. Santos. First of all, excuse me, it seems today we have the fruit of the Di Giambattista case about why it's advantageous to the Commonwealth and police, too, to tape record interrogations that occur while someone is in custody. And because of that, we know within the precision of a tape recording what it was that was being said. And I included the transcript that was introduced as Exhibit 104, along with the tape. The audio tape itself was Exhibit 103 at the trial, because through the custom of our court reporters, what was being played to the jury on the tape wasn't actually transcribed in part of the transcript. In this way, the court has it at its convenience for this argument. And if one turns to page 35 and 36 of the Commonwealth Supplemental Record, you'll see the exact portion here that's a question. And as Justice Botsford said, marked out from what the jury heard as redacted at the top of line 1 and 2 on page 36 is, I want a lawyer because you keep, you ask the dash dash, ask Lou that. It suggests that that wasn't an ellipsis. That is a mark for a change in the direction of the statement that Mr. Santos said, you ask Lou that. I'm not going on with this conversation. I want a lawyer because you keep, ask Lou that. You keep asking me about what I want you to ask Lou about, is what that ellipsis is. I don't think there was anything else missing in the transcription that you would hear on the tape. And as far as what happened when the knock at the door and the break came, you'll see on page 37 that the officers doing the interrogation, Trooper Baker and Detective Erickson, realized there's a knock at the door as found. And the tape in the interrogation room does not stop but they step out for what the judge found was about 3 minutes, and then they came back and resumed, as it indicates at line 10. What we have here, unfortunately, through all the wisdom of Miranda and D. Giambattista, is proof again that what people say is not always as clear as we would like it to be when trying to apply bright line standards. And because of that, the officers were permitted and proper in acting on what I would describe more as a conditional request for an attorney than an ambiguous request for an attorney.
May I ask you a hypothetical? If
Yeah.
if a person said, I don't want to speak to a lawyer, would it, in your view, be okay for police to say, why not?
I'm sorry.
Just for clarification?
I don't want, I have to actually clarify what you said, Your Honor. I didn't quite hear the middle of,
A defendant
yes.
says at some point, I want a lawyer. Can the police ask why the person says they want a lawyer?
No, a non-ambiguous and non-conditional direct statement, I want a lawyer, is sufficient to stop without further
The
inquiry.
person says, hypothetically, I want a lawyer because.
Well, even because doesn't suggest ambiguity or condition. As we see in the Santos case, the defendant asked for a lawyer and said, why? You know, I don't want to continue talking to you. I want a lawyer. So he gave an explanation, and he invoked, in a sense, well, not in a sense, he invoked directly both his right to silence and his right to an attorney. But he did it as an assertion, as opposed to situations where it's more in the form of a condition. You know, if you're going to do this, I would like to do that. If you're going to do more questioning about Lou's borrowing a car, this white car, then I don't want to talk about that. I want to have a lawyer.
In
And
this
they
case,
asked, huh?
in this case, at the end, he actually did invoke his right to counsel.
At the end of page 120 of the transcript and 120 of the supplemental record, he, as the judge found too, he knew exactly how to stop the conversation when it got to the point that he felt it was accusatory, and he wanted to stop and get a lawyer. And that's immediately the conversation stopped at that point, indicating that not only the defendant but the trooper and the detective also know what the law is. But they were operating here in real time, as you hear from a tape, even more than you do from a transcript. And there was testimony, you know, by the two of them in the room that perhaps Trooper Baker, who was asking the question, didn't actually hear exactly what was being said back to him, and that this is actually the product of those outside the room monitoring that heard better than the two there in the room what was going on, and they said, stop, we better check what this is. And what were the questions when they stopped? You know, Judge Gantz pointed out, I think it's at page 47 of the record, page 5 of the motion judge's findings. Although the trial judge didn't directly rule on this particular question, she found, except the defendant, page 47 of the record appendix, except that the defendant is repeating again that he wants to, is willing to talk to the police, but just doesn't want to talk to them about who borrowed or who was using the vehicle. And this is why I say this is where the request for counsel was contingent or conditioned on that particular line of questioning. And the law in this Commonwealth and in the United States is very clear that the defendant can be questioned as long as he chooses to answer questions, even though he doesn't want to answer a particular line of questioning. We have cases, Robidoux, you know, I don't want to talk about my family, Sakari, Senior, you know, they're all cited here. The line of questioning is something that can be invoked and so forth. And we see in...
Yeah, but I mean, we understand that, but that's not the issue here. The issue here is when you make a statement other than I don't want to answer those questions, the issue here is I want a lawyer.
But here,
and that has an entirely different effect.
But this wasn't, as the Chief Justice said, a hypothetical, though. This is a concrete situation where the request for an attorney was made specifically and squarely in conjunction to this line of questioning about you go ask Lou that, I don't want to answer those questions, suggest it appeared at the moment to be, you know, if you do that, I want a lawyer. And the court's cases, if I am under arrest, I want an attorney, said Mr. Gerard. You know, I'm thinking I might need a lawyer and want to talk to him before talking to you more, said Mr. Morganti. These were found to be as arguably clear, also arguably not clear, and conditioned. And in those cases, it was found to be proper for the police to stop and ask, not to continue questioning willy-nilly as if nothing had happened at all, but to find out whether this is clear or not clear. And this is what the Supreme Court of the United States has directed can be done and what it understands here, and this is what this court has followed for a good 20 years as far as how the police are to respond or are permitted to respond. And I suggest when you look at what Detective Erickson said when he came back from the break after they stopped, it was directly and specifically to find out, now are you telling me that if we talk about the car you want a lawyer and otherwise you're willing to talk? And as the trial judge, the motion judge found, that's exactly what the defendant made clear. That's what I'm saying. I want a lawyer if we're going to talk about the car. Otherwise, and there's not another comment about it, you know, for another 90 minutes of interrogation until the defendant says, I don't want to talk to you anymore about anything. I want a lawyer.
Can I switch
Yes.
topic? This is back to Justice Gantz's question to Ms. O'Brien about the statement, Olga Gonzalez's statement to the grand jury, which
Yes.
I take it there was no limiting instruction asked for or given. Is that correct? Is that
There was no instruction that this can be used substantively. I suggest when you
But
look.
there was no instruction saying it couldn't, was there?
No, there wasn't one there. There was an instruction with reference to prior statements if the jury found them to be inconsistent, that they went to credibility and they did not go to the substance. So I suggested that the jury.
Was that given?
That was given right before right before Olga Gonzalez testified. The judge went on for at quite some length without any objection whatsoever, as I indicated, page 44 of the brief. On April 17th, transcript from pages 11 to 22. As Olga was about to testify, the trial judge instructed the jury for 11 pages on joint venture and the use of statements made or to conceal. And then she went on and after and explained what. Now I'm not so 100% sure that at that moment she said it.
This is not a joint. This isn't a joint venture statement.
No. I apologize. I read what I wrote there. It's not referring to that. But the judge did give instructions on prior inconsistent statement during the testimony, and at the end also. So it said this is the way that this was being represented. I put the transcript in the record appendix, the transcript of Olga Gonzalez's testimony, because this is again particularly important. And at page 135 of the supplemental record, just page 35 that day, we see what she said. And I suggest it wasn't an offer of substantive use of the
But
testimony.
does the jury know that?
Does the jury know that? If you heard it, that's what you would think, that she's just saying, I can't remember. She was asked, do you remember testifying that you saw a gun? Yes. But
So the answer
this is
there is
one
yes.
time. Yes.
Yeah, I'm sorry. So taking that statement with her prior statements, the statements, just to refresh, that her brother comes in and she says, as she testifies, the other dude shot him, right? Your position seems to be in your brief, if I understand it correctly, that actually is admissible as a joint venture statement in furtherance of the venture?
The statement of the co-defendant to her
Yes.
is admissible, yes, as a statement in furtherance of the joint venture. And
In what way is saying the dude shot him in furtherance? It sounds like it's trying to distance himself from the venture. How is that in furtherance of? Just so I understand it.
He is trying, much as in the Burton case that I cite, he is trying to invoke the assistance in the immediate aftermath. This is like 5 minutes
Correct.
away from the crime.
Give me a shirt. I need a towel.
We need a place to be. We need some assistance. We need
Right.
this. We need that. Didn't do anything wrong. He doesn't specify that the two men who are outside with him, one of them is the shooter.
But the jury only sees two people. They don't know there was a possible third who's testifying. And no one, I don't think there's a third. I know you look puzzled. I'm trying to understand.
Yeah,
Well,
I'm not
you
sure
can-
what you mean. There was
Let me try to
a third
explain.
person, too, that came, and much was made of the fact that
He wasn't
Tom Clem-
accused in this case.
he wasn't accused. He wasn't charged by the Commonwealth. He was accused by the defendant.
In this case, I'm
In this
just
case.
asking the question, so I understand your position. I'm clearly not being clear. I'll do my best. So my question is, and I take it your answer to that is, yes, absolutely, you can accuse, you can say, yes, that dude shot him, and so your position is that's okay, it's in furtherance of the venture.
First, I don't think there was anything that's, the co-defendant said that dude shot him, referring to, that's not what was said.
He said he shot him.
He's saying that,
Well, I have
that
two
we went down there, I
statements
told
Yes.
I told this somebody, don't shoot him, and he did shoot him. All right, he didn't refer to the two people that were with him outside. The jury heard Olga testify and heard Tony Marquez testify that this guy named Claremont came shortly after there, that he took custody of what Tony
Yes.
Marquez thought was the gun, and he left with it. The defendant, in particular, tried to make it be that this was the fourth person that was seen by some witnesses, that he was a participant in the crime. How would the jury know who it was that the co-defendant was referring to here?
Well, that's part of my question, and I'll get to the last part. So they're allowed to testify. They're told they can take this in substantively. There's no objection to that. And then right after that, they're allowed to hear that one of the two people outside has a gun.
Well,
And you see no substantial risk in that.
Because I don't see a substantial risk in that, one, because that's not exactly what the jury heard. The jury heard that she remembered saying something to the grand jury that was inconsistent with her 6 times on direct, saying, I don't remember whether I saw a gun, I don't remember saying that to the police, and I don't remember saying that at the grand jury. And then when cross-examined by the co-defendant, that cross-examination ends again with, do you remember ever seeing a gun there or saying that to the police or the grand jury? No, I don't remember that.
No, well, she does testify. Do
That
you
one
remember?
time.
Yes, she does.
Yes, that one spot she says yes.
She is looking at a record saying, do you remember testifying, as she looks at the record? I mean, it's pretty clear.
She
that
also
said
had been,
it.
she had been asked 3 times looking at the record, do you remember saying this? And she said, I don't remember it, I don't remember it, I don't remember it. One time it's taken down that she says yes.
And
And,
just
and the defendant's argument is, how can we cross-examine someone that doesn't remember whether she saw it or not?
Yes, of course. So, but just to clarify as well, I think she said that the other guy shot the dude, and further that he told the guy not to, he still shot the other guy. So
Yeah.
it wasn't my colloquial language, so I'm just trying to put it together to see what your argument was. I understand the
No,
argument. I appreciate it. Thank you.
And I should say, the defendant is also arguing that there's a Bruton issue that arises here, and I put out the cases that say that this was sanitized if it was that he actually said Smokey did it.
Well, it
which
was
is-
sanitized as to Smokey. You could argue that the he is like the ellipsis that's discussed in the subsequent cases to Bruton, and you wonder, it's a question
Well,
that whether there's
Yes.
a he or an ellipsis at that point does the trick, at least under Gray.
Well, it's suggested, and I think this is one of the things the defendant is trying to take advantage of, that if other evidence, and here other evidence is Tony Marquez, tells you who he is, because Tony Marquez testifies that as I drove them over from the scene to the Olga's house, they're going back and forth saying, why did you shoot him? I had to shoot him. Why did you shoot him? I had to shoot him. That evidence doesn't mean that they can't be tried together because Olga's statement comes in as to what her brother said. The Supreme Court of the United States says that just because the jury can find out who is the joint venturer by other evidence introduced at the trial, that doesn't mean that you can't introduce that statement that Olga testified to. And that's really, that is where the defendant is arguing that substantive use was being made. And I suggest that what it is the jury had a basis to find substantively that the defendant was the shooter, but not from that statement, not from her saying, I don't remember what I said 6 times, and then says, well, yeah, maybe I did. I do remember saying something like that. Did this defendant cross-examine that witness, Olga Gonzalez, about her grand jury testimony and said you were very scared, you didn't want to be there, you didn't know what, all the types of things to confirm that maybe what you said, even if you remember it, saying it, wasn't true. I think that under the circumstances, there is no substantial likelihood of a miscarriage of justice, considering her testimony as a whole and the evidence as a whole. Even if, under some perception, one might think that she is saying, that guy had the gun. My brother told me that.
If I could move you back to the questioning at the police station, do you concede that he was in custody?
I certainly concede that this is not a Larkin situation. And, you know, as the court pointed out, this defendant was taken into custody by Lowell on warrants that were outstanding because they wanted to talk to him about this activity. They didn't suspect him at the time, and that's really the strongest point, you know, in the calculus of whether someone was in custody. But he was definitely in custody. He was arrested. He was held in a cell. He was questioned after 3 hours, for a couple of hours, and he wasn't free and released.
So for purposes of Miranda, we should view this as a custodial interrogation.
I believe you have to. I mean, I responded there because the defendant is saying that this court should reconsider Larkin. And this is just saying Larkin is inapposite, and this is really not a good basis to do so unless the court just wants to do it,
It's just
without needing to.
I mean, and in your view, you don't need to say this, but you will not support the application of Larkin to this case.
That's correct.
Yeah.
And while that was the motion judge's central basis, she did, as I say, at page 5, as Judge Gantz referred to, make the necessary findings as far as this was ambiguous. The defendant didn't mean that cut-off questioning. He wanted to continue at that point. And that is a basis for this court, and that's a basis for the Commonwealth's argument in its motion before the judge, citing Connecticut versus Barrett and Davis versus U.S., which are the Supreme Court legs of the argument, that even a request for counsel can be conditional. If it is ambiguous, it doesn't cut off questioning without some basis to inquire. And this Commonwealth has followed that law. So if there are no further questions, I rely on the brief and thank the court for its attention.
Thank you.